I would say that I don't believe the information in front of the court at this point proves he's actually a danger to the community.
So you're arguing to me that with all, this is legitimately 4 and 5 with another one pending in Wayne County and he's still using, you're saying it doesn't show to me that he's a danger to the community?
I think if he was driving, Assistant Public Defender Ben Dunaway on behalf of Mr. Barnhart, who stands to my right. Would you state your name for the record, please?
Philip Barnhart.
What are we doing?
Your Honor, Mr. Barnhart is prepared to waive his exams. I think there may be another issue that the APA wants to bring up, though.
Is the court in receipt of the bond violation report from Community Corrections?
I have a report dated September 10th, the progress report, yes.
Yes, Your Honor. And I understand that the defendant was released from jail on September the 2nd, went to Community Corrections to test on September the 3rd. And when he tested on September the 3rd, he tested positive for cocaine, THC.
This is where the judge starts piecing things together. Barnhart was released on September the 2nd and tested the very next day. And instead of coming up clean, he lit up the test like a Christmas tree. The defense tries to argue maybe he used before jail, but here's the catch. Cocaine doesn't usually linger more than 3 to 4 days unless you've been using heavily. The judge sees through it. Pattern or no pattern, this looks like a man still battling substance abuse. And here's a real question for you. Should past drug use excuse a failed test, or is it proof he can't follow bond conditions?
And Suboxone. I understand also that this was his first test, so there is an argument that he may not have been on bond at the time that these substances were consumed, therefore it may not be a bond violation. However, I did double check ex-jail and he was booked on August 31st and released on September the 2nd. So there were 3 days in custody. So it's possible that certainly the THC could have been from before. The cocaine I'm less certain of, with extremely heavy use, maybe 96 hours on cocaine, but no matter what, these are OWIs at least 4 and 5, and there's another pending OWI in Wayne County. I'm very concerned that he is not able to control his substance use and is a danger to the community.
Your Honor, I believe there's a window that would make this not a bond violation. I think if he would have used on August 30th or the 31st.
But if this is a 5 and this is showing up in his system at all, I would consider him a danger to the public and that his bond is inappropriately set. So I'll let you make your argument, but.
Can I have just a second, Your Honor?
Sure.
So, yeah, I just think there's possibilities that he's not used after being arrested. And those.
What?
I mean, cocaine could stay in his system for up to a week if there's heavy use. So the failure.
Let's say, I don't know, a week, but let's say I agree with you regarding that. Then his bond, and this is what I'm saying to you, then his bond on these operating while intoxicated, I have 2 in front of me and there's another one in Wayne County, then I think that his bond in these cases is inappropriately set.
And here's where the tension spikes. The judge lays out Barnhart's long record, multiple OWIs, another case pending, a string of priors, and Barnhart actually laughs. Think about that, laughing while the court lists out how dangerous your behavior is. That's not confidence, that's arrogance. In many judges' eyes, that kind of smirk is almost as damning as a dirty test. It shows no remorse, no fear, no accountability. And let's be honest, if you were facing the possibility of your bond being yanked, would you ever risk mocking the court like that?
And what I mean by that is that I clearly have these 2 cases. There's the other one in Wayne County. He's got priors and he's still using.
I think I'm fine. I think that's all factually true, Your Honor. Or he's at least not passing the test. Would the court be willing to have him test today?
Would he come back clean?
Yes, sir.
But here's again my problem, counsel. My problem is really the danger to the community. Because I have an incident that occurred in February of 23. This other one occurred in July of 2023 or 23. He's got a pending Wayne County one. He's got prior ones and he's still using. So I don't know that he should be out because at some point luck's going to run out.
This is where the judge really lays it down. He doesn't care if Barnhart claims he's not driving. What matters is history. Multiple OWIs and insanely high BAC in past cases, over 0.3, which is life-threatening in itself, and a track record of ignoring the law. The judge is clear. It's only a matter of time before luck runs out and someone gets killed. That's the heart of this case. Is society supposed to gamble with public safety just because Barnhart swears he's staying off the wheel? What do you think? Should the system give him another chance? Or is this the point where it has to draw the line?
Driving is absolutely dangerous, but there's no dispute. I think if he's using drugs in his own home, I don't believe that's a danger to the community that rises to the level of him needing to be incarcerated. I think he can remain out if he fails a test. That would be a bond violation at this point because he has been on bond since, I think that would be the 29th, 28th or 29th. So if he fails the test at this point, that would conclusively prove use while on bond. And I think absolutely the court at that point would have undeniable jurisdiction to revoke his bond. I would say that I don't believe the information in front of the court at this point proves he's actually a danger to the community.
So you're arguing to me that with all, this is legitimately 4 and 5 with another one pending in Wayne County and he's still using, you're saying it doesn't show to me that he's a danger to the community?
I think if he was driving, I wouldn't absolutely not even argue that, no question. I think him failing those tests, and we don't have a pattern or anything like that. You know, we don't know if this is a one-time slip up. We don't know if he's used while he was on bond. I think the court could allow him to test today and that would solve the problem.
Can I respond?
Right.
I would wholeheartedly disagree that there's no pattern. I think that the defendant having 3 previous convictions for OWI in 2002, 2004, and 2016, a 2023 Wayne County case, a 2023 Washtenaw County case, and a 2024 Washtenaw County case is absolutely a pattern. Furthermore, Your Honor, in this matter, if I recall correctly, and I think I do, but I will make sure, I believe his BAC was incredibly high. And I'm going to double check that before I get that search into the court. But if I recall correctly, I think in both cases, his blood alcohol content was above a 0.3.
That's correct, Your Honor.
So we are not, if this isn't a pattern, I don't know what a pattern is. People would request that the court find that the bond is an abuse of discretion and set a higher bond and remand.
I just don't think the circumstances have changed since the bond was set because and I know the court could disagree, but we don't believe there's evidence he's used since the bond was set by the magistrate, at least conclusive evidence. There, you know, it's up in the air as far as he failed the test.
You keep arguing the use. The argument is, even if I give you that, the argument is I don't know that he should be out. Any use, given his record, and he's out on basically a PR, I think is an abuse of discretion. Now, if you want to argue that with me, certainly I will hear you.
Okay. I think it would not be abuse of discretion because of the length of time that has passed. So, you know, we're already into August 2025. The positive test, we can't really deny it, but what we can say is he's not.
And here comes the hammer. After hearing both sides argue back and forth, the judge decides the risk is too high. Barnhart's bond gets changed from a personal recognizance, basically a free pass, to a hefty $25,000 cash or surety. That's not just a slap on the wrist. That's the court saying, we don't trust you out here unless you put serious money on the line. This shift changes everything for Barnhart. Suddenly, freedom isn't guaranteed. It's a hard reminder that when you laugh at the system can laugh right back with your bond revoked.
Drive car. So the extreme danger to the community that comes with intoxicated driving is not present. obviously there's some danger to the community in hard drug use, but I believe it's less. I believe it can be managed with restrictions such as continued testing. If he fails again, he's obviously used while on bond. The court could do that. I think the court could order increased testing. You could put him on 3 times a week. I think he was on 1 time a week. I mean, the court could order testing every day if the court felt that necessary. There's a lot of options other than just incarcerating him.
What did you wish these set for?
I'm sorry?
What did you wish these set for? Preliminary examination?
No, he's going to waive.
He's waiving. All right. So at this point, what I will do is his bond is going to be changed. I'm going to set it at $25,000 cash or surety. Sir, you're waiving your right to preliminary examination in these cases? Sir. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them? Yes, sir. You understand you will not have that hearing on either one of these matters, and that this will proceed to circuit court for further resolution? Sir. People also waive their right.
We waive, Your Honor. I do believe he previously posted $25,000.
Oh, are on both of these?
I think that's what my notes reflect, is that that's what it was set at.
I mean, I thought they were PRs.
It might have been PRs, and $25,000 PRs, but
I have on each of these that they're PR.
Oh, I apologize, Your Honor, my mistake. Thank you.
So people do waive.
We do.
Preliminary examination haven't been waived. Defendants bound over to circuit court on the single count in each case.
We will stand mute, waive the formal reading.
Defendant having waived formal reading, standing mute. Court will enter not guilty plea pretrial. Custody pretrial date.
September 24th at 1:30 with Judge Conlon.
September 24th, 2025, 1:30 before Judge Conlon in each of these matters. The bond, as indicated, is set in each case. It will be changed from a personal recognizance to a $25,000 cash or surety. Defendant is remanded. Yes, you may. What was that date again?
24th, Your Honor.
So let's recap. Barnhart walks in facing multiple OWIs, fails his very first drug test after release, laughs in the middle of his hearing, and walks out with a $25,000 bond. The judge made it crystal clear. This isn't just about Barnhart. It's about protecting the public from someone who's proven they can't stop drinking and driving. And here's the bigger picture. When does personal addiction cross the line into public danger? This case shows just how thin that line really is. If you found this case as shocking as we did, hit that like button, drop your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.